To order, could I ask everyone to register their attendance? Clerk will open the roll. All members are here are present. Clerk will close the roll. We do have a quorum. A couple of administrative items and administrative actions. The bills that I'm going to read are all items that are going to be continued to 2027. And I'm going to read 5 bills here. House Bill 364, patroned by Delegate Doherty. House Bill 421, patroned by Delegate Cole. House Bill 604, patroned by Delegate Willett. House Bill 853, patroned by Delegate Cousins. House Bill 863, patroned by Delegate Cousins, are all going to be continued to 2027. Can I get a motion? And a motion and properly second. All in favor say aye. Aye. Okay, all those bills are continued into 2027. So with that, why don't we go into our criminal subcommittee docket? And for that, I'll turn to Chair Watts.
Thank you, Mr. Chairman. First, I would like to move all of the amendments and substitutes for those bills that are in the uncontested block.
Got a motion to amend to approve all the amendments and substitutes. Motion properly second. All in favor say aye. Aye. Opposed? Chair Watts.
Thank you, Mr. Chairman. The first bill in the block, I believe, needs to be pulled from the block because it needs an additional amendment. So if I can go on to the second.
Yep, please. The
second bill in the block is HB 443 by Delegate Hope, Chairman Hope, and what it does is for several of the judicial districts, as both juvenile as well as general, and several of the judicial circuits, it authorizes additional judgeships as it has been documented the workload merits. The next bill, HB 459 by Cohen, pertains to a victim's right to non-disclosure of certain information if they are a victim of hate crime. They may choose to have that information, such as the site of the crime, such as their name and other identifying information released, but until they allow or their next of kin allows, that information shall be kept confidential. It also prohibits at the request of the victim, the Court of Appeals and Supreme Court from listing the first or last name of the victim of a hate crime in an appellate decision. The next bill is HB 250, Delegate Hernandez, and this pertains to providing that no clerk shall charge a fee to an attorney for secure remote access to non-confidential court records when the attorney is in fact certified by the Virginia Indigent Defense Commission and in fact so operates. It allows the clerk at any time to withdraw that access should it be abused or should the attorney no longer participate in the indigent defense work. The next bill is 567 by Carney, and this bill provides that notwithstanding any other provision of law, if there is a request for a report of aggregate case data is made by the Commonwealth of the attorney for the Commonwealth to insist in the performance of their duties, then the clerk of the Executive Secretary of the Supreme Court of Virginia, may provide such a report of that aggregate case data, which shall include the name, date of birth, and last 4 digits of the Social Security number of any party, if such information is only for cases arising within the jurisdiction of that attorney for the Commonwealth. And of course, the substitute requires that such information be redacted before the attorney for the Commonwealth further disseminates the report, and that all such information be kept confidential. The next bill is HB 1298, Delaney. And it expands the current process for issues of writs of vacatur for victims of human trafficking to include any ancillary matters that are defined in the bill and any charge or arrest related to a qualifying offense as defined in current law. It adds a definition of official documentation and rebuttable presumption that a person's participation in an offense was the result of having been a victim of human trafficking if there's an official documentation of the petitioner's status as a victim of human trafficking at the time of offense. The next bill is HB 1485, Delegate Hope, and it increases the maximum number of judges on the Virginia Court of Appeals from 17 to 21, and it also provides that the Supreme Court of Virginia shall prescribe by rule the number of judges needed for the Court of Appeals to sit en banc, and that such number shall not be fewer than 13. Additionally, the bill permits the Court of Appeals to summarily affirm the decision below in certain civil cases rather than having to go further. The line amendment also includes a delayed effective date of September 1, 2026. That is the end of the uncontested block. And again, if we could address the need for the amendment on the first bill.
All right. Well, before we do that, why don't we go ahead and by voice vote on House Bill 443 to incorporate House Bill 46 and House Bill 194.
My apologies. I thought that had been part of my general motion. This would simply incorporate individual districts and circuits where the authorization was also put forward in separate bills.
Okay, so we got a motion to incorporate House Bill 46 and House Bill 194 into House Bill 443. Second. The motion properly second. All in favor say aye.
Aye.
Aye. Okay, so do we want to go back to House Bill 191, and do you want to do the amendment there? Do you want to do it now? Chair Watts? Can I get Mr. Hatcher, do you want to
If we could report the amendment.
Yes, thank you, Mr. Chair, members of the subcommittee. The substitute that you've adopted puts the bill in the posture that no minor shall be subject to arrest or prosecution for a qualifying defense as defined in relevant law. An amendment needed to be added that was left off during the drafting that says, if at the time of such offense, the minor was a victim of sex trafficking. So if this is adopted, it will just be added to the substitute once the vote happens.
Okay.
Again, I so move.
All right, got a motion and properly second to adopt the substitute. All in favor say aye.
Aye.
Opposed? All right, Chair Watts, you want to explain the bill now? Or did you already do that?
On that, I have not reported it. Again, this, if I may, HB 191, the underlying bill, allows for the possibility that a minor who was a victim of sex trafficking to have the charges of prosecution for prostitution, immune from prosecution under this subsection.
Okay, and the subcommittee recommended reporting.
I'm sorry, this is part of the uncontested block, so yes, it was recommended reporting with substitute unanimously. Thank you, Mr. Chair.
Okay. So any members wish to pull any bill from the block? All right, seeing none? All right, clerk will please open the roll on the block. Clerk will please close the roll. All right, the block reports by a vote of 20-0. Chair Watts.
Thank you, Mr. Chairman. And then I have in a block, I believe I'm in the right block, this would be bills recommended to report that are uncontested, but they need to be referred to appropriations. And I have two of those, and I would move the substitute for both of those bills in the block.
Got a motion. Simon seconds. All in favor say aye. Aye. Opposed? All right. Both bills are before us. Chair Watts.
And the first one is HB 127 that makes various changes to provisions regarding bail hearings, including the appointment of counsel for the accused, the information provided to the counsel for the accused, and the requirement that counsel for the accused, when practicable, be provided with adequate time to confer with the accused prior to any bail hearing. And finally, compensation of counsel for the accused. It has a effective in due course that the chief judge in each circuit shall create a plan to be completed by November 1, 2026, that establishes a means by which the jurisdiction will meet those provisions, and the remaining provisions of the bill then have a delayed effective date of January 1, so that there is a plan before the effective date. The substitute clarifies how the procedure shall be done in jurisdictions served by public defenders and how such procedures may be done in other jurisdictions. Again, the subcommittee reported recommending unanimously with substitute. The second bill is HB 885, and that is Delegate Hope with the substitute establishes a court date reminder program to be developed or procured by the Executive Secretary of the Supreme Court for the purposes of reminding criminal defendants to appear at each of their scheduled court appearances. The bill directs the program to send a text message to any defendant, a notification with a criminal case in a general district court or circuit court for whom the court has a telephone number prior to any scheduled hearing requiring his presence, permits the defendants to opt out of participating in the program. And finally, the substitute clarifies that someone adjudicated as a delinquent, as a minor, can participate also in the process, and then notification can be for probation, but that any such modification can only be for the marijuana convictions and not for other convictions that that juvenile had received.
Just ignore that.
Just, the man behind the green curtain, just ignore him.
All right, so these both
That
these
then
bills
is in fact the substitute. Again, both were recommended that be reported and referred to appropriations unanimously.
okay. So on these two bills, House Bill 127 and House Bill 885, does anyone wish to pull any of these bills out of the block? We're going to vote on them in a block. All right, seeing none, I ask the clerk to please open the roll. Members, please cast your votes on the block. All members have cast their vote. Clerk will please close the roll. Bill reports and refers with substitute to appropriations by a vote of 20-0. Chair Watts.
Thank you, Mr. Chairman. And now we have a series of bills that were contested, and they are first, HB 43 by Delegate Simon. I move the line amendment.
Got a motion and properly second to move line amendment. All in favor say aye. Aye. Opposed? All right, Chair's bill's before us. Chair Watts.
This bill would abolish the common law crime of suicide, and as amended has a delayed effective date of July 1, 2027, in part to allow the Bureau of Insurance of the State Corporation Commission to review the effect and implications of abolishing the common law crime of suicide or insurance through the Commonwealth and submit its findings and any recommendations by November 1st of 2026 to the chairs of the House and Senate committees for courts of justice. The committee recommends reporting as amended 7-3, and I would so move.
Got a motion and properly second to report House Bill 43. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. All members have voted. Clerk will please close the roll. House Bill 43 reports with amended 14-6. Chair Watts.
Thank you, Mr. Chairman. The next bill is HB 172, Delegate Mehta, and it has a substitute, and I so move.
The motion properly second to move the substitute. All in favor say aye. Aye. Opposed? Substitutes approved. Chair Watts.
Thank you, Mr. Chairman. The substitute provides that the accused can allows for the jury to ascertain punishment, but provides that the accused may withdraw a request for a jury to ascertain punishment up until the commencement of the sentencing proceeding. The substitute also provides that counsel for either party shall have the right to examine jurors regarding the potential punishment or ranges of punishment, regardless of whether the jury will ascertain punishment, and the court or counsel for either party may inform any person or juror during voir dire that the potential range of punishments so that you can ascertain whether the person or juror can sit impartially in the guilt phase. Current law provides that the court or counsel for either party may inform any person or jury during voir dire, but as to the potential range of punishment to ascertain. The substitute adds a provision for juveniles being tried in circuit court before a jury to also be included within the provisions of this bill. The subcommittee recommends reporting with substitute 7-3, and I so move.
Second.
And a motion and properly second to report House Bill 73 with substitute. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 172 reports with substitute by a vote of 14-6. Chair Watts.
Thank you, Mr. Chairman. The next bill is HB 246, Patron Delegate Watts. And it provides an affirmative defense to prosecution for persons for the charge of assault or assault and battery against certain specified law enforcement officers for which the enhanced Class 6 felony and 6-month mandatory minimum applies. Only if such person proves by a preponderance of the evidence that at the time of the assault or assault and battery, the person's behavior were a result of mental illness, neurocognitive disorder, including dementia or intellectual disability or developmental disability, such as autism spectrum disorder. And it also requires that the person meet the criteria for issuance, or possibly that the person met the criteria for issuance of an emergency custody order. It requires that the person or counsel give the notice in writing to the attorney for the Commonwealth at least 60 days prior to trial in circuit court, 14 days if the trial is set within 21 days of the last court appearance. And such notice is not given, the person proffers such evidence at his trial as defense. The court may then, in its discretion, either allow the Commonwealth to a continuance or, under appropriate circumstances, bar the person from presenting such evidence, and any continuance shall not be counted against speedy trial. Lastly, the bill provides that if the person doesn't prove his behaviors were a result of mental illness, intellectual disability, developmental disability, or neurocognitive disorder, but the evidence establishes that his mental illness and the other conditions or the other conditions otherwise contributed to his behavior, the finder of fact may find the person guilty of a misdemeanor rather than felony assault and battery. The bill also provides that the affirmative defense shall not be construed to allow an affirmative defense for voluntary intoxication. The subcommittee recommends reporting 7-3 and referring to appropriations, and I would so move.
Second.
A motion and properly seconded to recommend reporting House Bill 246 and refer to appropriations. Any members seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your votes.
You're from Prince William, right? I know that law enforcement situation.
All members have voted. Clerk will please close the roll. House Bill 246 reports and refers to appropriations by a vote of 13-7. Chair Watts.
HB 247, also Patron Watts. There are line amendments plus a new amendment from council. I've moved the line amendments.
All right.
Second.
Well, motion properly second to move the line amendments. All in favor say aye.
Aye.
Opposed? All right.
And I believe
Hatcher.
the additional amendment from council is clarified, so if I may, I would like to move them at this time.
Mr. Hatcher, do you want to report the amendments?
Yes, Mr. Chair, members of the subcommittee. This just simply includes developmental disabilities into the bill, so they're just little technical line amendments that then add that phrase into the bill.
Okay.
Second.
A motion and properly second to move the line amendments reported by council. All in favor say aye.
Aye.
Opposed? All right, Chair Watts, bills before us.
Thank you, Mr. Chairman, and this is a shorter explanation. This deals with, allows the court to defer and dismiss a charge pursuant to autism or intellectual disability as for deferred dispositions under the deferred disposition statute, and the charge may be considered as otherwise dismissed for purposes of expungement if indeed the full completion of the deferred disposition has been satisfactorily completed. The bill also clarifies that the defendant may request a hearing to determine the appropriateness of a deferred disposition at any time before or after the plea, but there must, however, have been an establishment of the factual pattern necessity that would support a finding of guilt. And finally, the bill provides that no statement made by the defendant at any hearing or examination conducting pursuant to the determination shall be admissible in any criminal proceeding except for the criminal proceeding of perjury or impeachment. I move the subcommittee the subcommittee recommended reporting with substitute 8-2, and I so move, and referring to appropriations as amended, and I so move.
Thank you. I got a motion properly second to report House Bill 247 with amendments and substitute and amended to appropriations. Any members wish to seek recognition on this bill? All right, seeing none, ask the clerk to please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 247 reports with substitute as amended. It's not a substitute, as amended. What was acting against that vote number, but it did pass. All right, Chair Watts.
Thank you, Mr. Chairman. HB 290, Patron Anderson, was referred to us from education, and it deals with false statements as to the school division or attendance zone residency. The question before the criminal law subcommittee of whether or not it was appropriate to reduce this from a criminal to a civil penalty, both of which would still be include a fine not to exceed $250 in addition to the charge penalty. The committee recommended. No, I know. Yep, thank you. I got it. The subcommittee recommends reporting, in fact, and reducing it to a civil penalty by a vote of 8-2, and I would so move.
I had a motion properly second to report House Bill 290. Any members wish to seek recognition on this bill? All right, seeing no requests to speak, clerk will please open the roll. Members, please cast your votes. Clerk will please close the roll. House Bill 290 reports by a vote of 14-6. Chair Watts.
Thank you, Mr. Chairman. HB 357, patron by Colson. There is a line amendment. I so move.
And a motion properly second to move the line amendment. All in favor say aye. Aye. Opposed? All right. Amendment's approved. Chair Watts.
Thank you. The bill removes the conditions requiring that any person arrested for a felony who's previously been convicted of a felony and is presently on bond for an unrelated arrest in any jurisdiction or is on probation or parole be released only on secure bond. It allows the option then to the factors that a judicial officer shall consider, however, in making a bail determination, and the person's current bond status for an unrelated arrest in any jurisdiction, and also clarifies the conditions under which it is to be determined that a person is in probation or parole in another jurisdiction. The subcommittee recommends reporting as amended 8-1 to apply to the jurisdiction in question, and I would so move.
We got a motion properly second to report House Bill 357 as amended. Any members wish to seek recognition? Seeing none, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 357 reports with amendment by a vote of 14 to 6. Chair Watts.
Thank you, Mr. Chairman. The next bill does not have any amendment or substitute. It is HB 852 by Delegate Cousins, and it eliminates the fees for the cost of court-appointed counsel or public defender representation for persons who are determined to be indigent. The bill also eliminates fees for persons who utilize a jury trial. Such persons. The bill contains a reenactment clause for such elimination of fees. The bill then also outlines a work group with all relevant stakeholders, which I won't read for the sake of time, to look at current collection practices, where funds that currently received or collected are directed, at the impact of the reduction in the burden on individuals currently assessed with such fees, what other states have done to avoid or eliminate public defense and trial by jury costs, and a plan for eliminating these fees no later than July 1, 2027. And the bill requires the work group to submit an executive summary and report of its findings to the governor and to the General Assembly by November 1st, 2026, that includes current practices for implementation and collection and other such recommendations, including the planning of the elimination. The subcommittee recommended reporting 7-3 and referring to appropriations, and I would so move.
Second. And a motion properly second to report House Bill 852 and refer to appropriations. Members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your votes. Clerk will please close the roll. House Bill 852 reports and refers to appropriations by a vote of 14 to 6. Chair Watts.
Thank you, Mr. Chairman. HB 933, Patron Delegate Simon. There is a substitute, and I so move.
Second. A motion properly seconded to remove the substitute. All in favor say aye. Aye. Opposed? All right, substitute is included. Chair Watts.
Thank you, Mr. Chairman. The substitute provides that any person charged with a felony offense or misdemeanor offense, or who is convicted of a felony offense or misdemeanor offense, and the execution of the sentence is suspended, who willfully fails to appear before any court or judicial officer as required, is guilty of a misdemeanor punishable by no more than 30 days in jail. Under current law, such person is guilty of a Class 6 felony, and if charged or if charged with a felony, or a Class 1 misdemeanor if charged with a misdemeanor for such a violation. The substitute also requires that the court consider mitigating factors when determining whether a person willfully fails to appear, including illness, injury, or other unforeseen medical condition, unforeseen transportation problems, an inability to obtain adequate dependent care, and any affirmative steps taken by that person to communicate or remedy his failure to appear before any court or judicial officer as required. The subcommittee recommends reporting with substitute 7-2, and I so move.
Got a motion and Maldonado seconds to report House Bill 933 with substitute. Any members wish to seek recognition? Seeing none, clerk, please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 933 reports with substitute by a vote of 14 to 7. Chair Watts.
And finally, Mr. Chairman, HB 950, patroned by Delegate Lopez. There is a line amendment, and I so move.
A motion properly second to remove the line amendment. All in favor say aye. Aye. Opposed? All right, bill's before us. Chair Watts.
The bill adds the Department of Environmental Quality to the list of exceptions to the warrant requirement for the use of an unmanned aircraft system by public bodies. The bill pertains to the DEQ's implementation and enforcement of the Water Resources and Wetlands Protection Program, the Virginia Erosion and Stormwater Management Act, and erosion and sediment controls in localities without a Virginia Erosion and Stormwater Management Program. The amendments provide that such systems shall be used for civil enforcement of such laws against the permittee. The subcommittee recommends reporting as amended 6-3, and I so move.
A motion and properly second to report House Bill 950 as amendment. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your votes.
Thank you.
Clerk will please close the roll. House Bill 950 reports as amended by a vote of 14-7. Is that your last one, Chair Watts?
That
For your report.
concludes my report.
All right. Thank you, Madam Chair. Over to Chair Simon for the Civil Law Subcommittee report.
Thank you, Mr. Chairman. I move all the amendments and substitutes in the uncontested block.
Second.
Got a motion and properly second to move all the substitutes and amendments that are uncontested. All in favor say aye.
Aye.
Opposed? All right. Chair Simon.
All right, Mr. Chairman, the first bill up is House Bill 100 from Delegate Ballard that provides that an affidavit presented by any person having possession of a small asset to the designated successor of a decedent shall be on a form prepared by the Office of the Executive Secretary of the Supreme Court. The subcommittee recommended reporting by a vote of 10-0. House Bill 224 from Delegate Hope adds the methods by which the Department of Social Services can administratively establish paternity for the purposes of child support enforcement, and adds that the lists of ways that a parent and child relationship may be established in domestic relations proceedings under Title 20. This is a recommendation of the Boyd Graves Conference. Subcommittee recommended reporting 10-0, and I so move. House Bill 448 is my excellent bill, and it sets forth the fees that a clerk of the circuit court can charge for recording and indexing a multi-purpose deed of trust or mortgage, described in the bill as a deed of trust or mortgage, whether or not commercial, that serves multiple purposes and contains 2 or more components. Subcommittee recommended reporting 10-0, and I will so move. House Bill 581 from Delegate Glass has to do with the unauthorized use of name, portrait, voice, and likenesses. It expands the existing ability for any person to maintain a suit in equity, including the accompanying remedies available for the unauthorized use of his name, portrait, or picture for advertising purposes or for purposes of trade, to include the unauthorized use of his voice or likeness. The bill contains a reenactment clause. Subcommittee recommended reporting 10-0. House Bill 768 from Delegate Herring provides that a circuit court or district court may order a custody evaluation to assist with determining the custody or visitation arrangements of a minor. Current law provides that such custody evaluations can be ordered in a proceeding for custody or visitation before Juvenile and Domestic Relations District Court. This is a recommendation of the Family Law Coalition. Subcommittee recommended reporting with amendment by a vote of 10-0. House Bill 910 from Delegate Shin, as amended by the substitute, requires the Department of Housing and Community Development to conduct a review of parcels owned by certain partnerships, corporations, or real estate investment trusts in its comprehensive statewide housing needs assessment, conducted at least every 5 years. As amended, the substitute was recommended for reporting by a vote of 8-0. My House Bill 929 is the Uniform Power of Attorney Act. It amends the definition of acknowledged as it relates to a power of attorney under the Uniform Power of Attorney Act to being purportedly verified before notary public or other individual authorized to take acknowledgments. Under current law, acknowledged as it relates to a power of attorney under the Act means verified before notary public or other individual authorized to take acknowledgments. This bill further eliminates the provision that the Act prohibiting a person relying in good faith upon an acknowledged power of attorney that is invalid where such power of attorney contains a forged signature of a principal. Subcommittee recommended reporting 10-0, and I will soon move. House Bill 1020 from Delegate Reeser adds to the accrual provision for personal injury actions resulting from sexual abuse during infancy or incapacity of a person, that accrual occurs when corroborative evidence, as defined in the bill, is discovered or by the exercise of due diligence reasonably should have been discovered. Subcommittee recommended reporting 10-0. And finally, House Bill 1119 from Delegate Navarre removes the requirement of a clerk of court in a guardianship proceeding to forward a copy of an order appointing a guardian and a copy of the certificate of qualification to the Department of Medical Assistance Services, because DMAS says we don't keep those anymore. Subcommittee recommended reporting by a vote of 10-0. And so I move to report the entire block with substitutes and amendments.
Second.
So, second.
Got a motion and properly second to report all those bills on the uncontested block. Does any member wish to to pull a bill from the block? Use your request to speak button. Okay, seeing none. Clerk will please open the roll to vote on the block.
Ian, Bob, you are to that position.
All members have cast their vote. Clerk will please close the roll. The block approved 21-0. Chair Simon.
All right, moving on to the next bill is a contested bill that needs to go to appropriations. That's House Bill 775 from Delegate Thornton. As amended by the substitute, adopted by the substitute. There's a committee substitute. I move the committee substitute.
Motion and properly second to approve the substitute. All in favor say aye.
Aye.
Opposed? All right, substitute's approved.
As amended by the substitute, which is very helpfully written here for me, the bill adds a definition of reasonable efforts for the purposes of hearings related to the foster care of and petitions for the termination of parental rights. The bill further directs the Department of Social Services to promulgate new regulations defining types of abuse and neglect, specifying that in situations where neglect is the result of family poverty and there are no outside resources available to the family, the parent or caretaker shall not be determined to have neglected the child, but the local Department of Social Services shall provide appropriate and timely services to the family. Subcommittee recommended reporting with substitute 7-1. I think that the one was because we were still working on some amendments. My understanding, just for the information of the committee, is there are some further amendments to the bill that have been agreed to in concept that aren't quite ready for today, but because this bill needs to go to appropriations, I think all the stakeholders have agreed that they'll try and get those additional amendments added to the bill up in the appropriations room. Okay. And so with that, Mr. Chair, I move that House Bill 775 be reported and report and referred to the Committee on Appropriations with substitute.
Second. Okay, we got a motion and properly second to report House Bill 77 with substitute and refer to appropriations. Any members wish to seek recognition on this bill? All right, clerk will please open the roll. All members have cast their vote. Clerk will please close the roll. House reports, House Bill 775 reports and refer substitute to appropriations by a vote of 21-0. Chair Simon.
All right, Mr. Chairman, now to the contested block. This bill may have a patron problem, we don't know, but it's House Bill 303 from Delegate Sullivan. It specifies that divorce may be decreed on the grounds of adultery, provided that such adultery occurred prior to the final separation of the parties. Bill further allows for divorce from bed and board to be decreed on the application of either party upon the parties living separate and apart. Under current law, a divorce from bed and board may only be decreed for cruelty, reasonable apprehension of bodily hurt, willful desertion, or abandonment. The bill specifies that no waiting period is required for the filing of such a divorce, but the decree of such a divorce may only be decreed pursuant to certain requirements otherwise specified in the law. This is a family law coalition bill. Subcommittee recommended reporting by a vote of 6-2, and I so move.
A motion properly seconded to report House Bill 303. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your vote. Clerk will please close the roll. House Bill 303 reports by a vote of 15-6. Chair Simon.
Next on our list is House Bill 342 from Delegate Martinez, and it requires that paper copies of any standardized form developed and utilized by the Judicial Inquiry and Review Commission and any standardized form developed and utilized by the Department of Magistrate Services in the Office of the Executive Secretary of the Supreme Court of Virginia for the filing of a complaint be made available to the public in the clerk's office and all state courts in the Commonwealth. So when you go to court, if you don't like what the judge decided, you have a form available and you can fill it out right there on the spot. Subcommittee recommended reporting by a vote of 8-2, and I so move.
Second.
And a motion properly second to report House Bill 342. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your vote. Clerk will close the roll. House Bill 342 reports on a vote of 14-7. Chair Simon.
House Bill 556 has a subcommittee substitute. I move the subcommittee substitute.
Motion properly second to move a substitute. All in favor say aye.
Aye.
Opposed? All right, substitute's approved.
All right, this bill from Delegate Reeser, as amended by the substitute, specifies that the information necessary to enter a final decree of divorce or annulment of marriage shall include a party's social security number and or control number issued by the Department of Motor Vehicles, only if it's known and available. Subcommittee recommended reporting 8-1, and I so move.
Got a motion properly second
With
to report
substitute.
House Bill 556 with substitute. Any members wish to seek recognition on this bill? All right, clerk, please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 556 reports with substitute by a vote of 19 to 2. Chair Simon.
House Bill 601 from Delegate Hernandez has to do with exemptions from garnishment. And it requires certain financial institutions to automatically exempt from garnishment a minimum protected account balance defined in the bill as the combined total of not more than $1,000 in a judgment debtor's account or across multiple accounts in the same financial institution. And 2, a protected amount of certain benefit payments defined in the bill that have been deposited into the account via direct deposit or electronic deposit within 2 months immediately preceding the day before a financial institution commences an account review. The bill describes an account review as a process of examining an account of judgment conducted by a financial institution upon such financial institution's receipt of a garnishment summons to determine if any eligible benefit payments have been deposited within the applicable time period, and if so, to calculate the total sum of such benefit payments and establish the total as a protected amount that shall be automatically exempt from garnishment. I know it sounds like this bill asks for the financial institutions to do a lot, but they actually came and supported the bill because they like having very clear guidelines and very clear rules for how they're supposed to conduct these things. Subcommittee recommended reporting this bill by 9 to 1, and with amendments. So this got amendments. Let me move the subcommittee amendments.
Motion and properly second to move the amendments. All in favor say aye. Aye. Opposed? All right.
And so the subcommittee recommended reporting with the amendments by a vote of 9 to 1, and I so move.
Yep. Motion properly second to report House Bill 601 as amended. Any members wish to seek recognition on this bill? All right, clerk will please open the roll. All right, why don't we go at ease?
You broke.
We'll vote on House Bill 601 as amended. Clerk is opening the roll. Please cast your votes. All members have voted. Clerk will please close the roll. House Bill 601 reports as amended by a vote of 21 to 1. Chair Simon.
Thank you, Mr. Chair. Now, this bill from Delegate Maldonado has to do with juvenile and domestic relations district courts. And there's a substitute. I move the subcommittee substitute.
Second.
Got a motion properly moved to report substitute. Move substitute. All in favor say aye.
Aye.
Opposed? All right. Bill's properly before us. Chair Simon.
So, Mr. Chair, House Bill 667 allows an unmarried non-citizen between the ages of 18 and 21 who has been abused, neglected, or abandoned to petition a juvenile domestic relations district court to be placed in the custody of the proposed legal guardian. This bill also includes such unmarried non-citizen in the definition of child, juvenile, and minor, as such terms are related to juvenile domestic relations court. This is necessary to allow these folks to retain their special protected status. And there's a subcommittee substitute. I move the subcommittee substitute. Did I already do that?
And a motion properly second to move the substitute. All in favor say aye.
Aye.
Opposed?
All right. The subcommittee recommended reporting with substitute by a vote of 6 to 2, and I so move.
All right. House Bill 667. Motion is report with substitute. Any members wish to seek recognition on this bill? All right. Seeing none, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 667 reports with substitute. I couldn't see that score, but that bid passed. Delegate Simon.
All right. Next bill, House Bill 872 from Delegate Cousins, has to do with possession of portable electronic devices in district court. And it requires the chief judge of each general district court, juvenile and domestic relations court, and circuit court to set a policy regarding the use and possession of portable electronic devices defined in the bill, and to publish that policy and let everybody know what it is. This is to deal with the problem of showing up at a courthouse and find out the local rules don't allow you to bring your cell phone in. And now you got to go find a place to stash it in the woods or in the bushes somewhere while you go to court because you didn't arrive by car. Subcommittee recommended reporting with substitutes. I move the subcommittee substitute.
Got a motion properly second to move the substitute. All in favor say aye. Aye. Opposed? All right, substitute's approved.
Subcommittee recommended reporting with substitute by a vote of 9-1, and I so move.
All right, got a motion, and Maldonado seconds. House Bill 872 with substitute. Many members wish to seek recognition on this bill. All right, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 872 reports with substitute by a vote of 22-0. Chair Simon.
Next up is House Bill 905 from Delegate Lopez that provides that the clerk of a circuit court may issue an order authorizing one or more persons resident in the circuit in which an application was filed to celebrate the rights of marriage in the Commonwealth. Under current law, only a circuit court judge may issue such an order. The bill further makes discretionary the entrance into a bond and the penalty of $500 prior to the performing the rites of marriage for a person authorized to celebrate the rites of marriage. Under current law, such entry is mandatory. So this makes the entrance of the bond totally discretionary. Subcommittee recommended reporting with an amendment. I move this subcommittee amendment.
Got a motion properly seconded for move the amendment. All in favor say aye. Aye. Opposed? All right, bill's before us.
And so the subcommittee recommended reporting with amendment 7-1.
Got a motion, Maldonado seconds. House Bill 905 as amended. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 905 reports as amended by a vote of 21-1. Chair Simon.
The House Bill 942 has subcommittee amendments. I move the amendments.
Motion properly second to move the amendment. All in favor say aye. Aye. Opposed? All right, bill's amended.
All right, House Bill 942 from Delegate Clark provides that a child shall not be considered an abused or neglected child, and no person shall be denied custody or visitation of a child based only on the fact that the child's parent or other person responsible for his care or the person petitioning for custody or visitation of the child possessed and consumed legally authorized substances. The bill directs the Board of Social Services to amend its regulations, guidance documents, and other instructional materials to ensure that such regulations, documents, and materials comply with, and that investigations and family assessments are conducted by local departments of social services in accordance with the provisions of this bill. Subcommittee recommended reporting with the amendments by a vote of 5-3, and I so move.
Got a motion properly second to report House Bill 942 as amended. Any members wish to seek recognition on this bill? All right, clerk will please open the roll. Members, please cast your vote. All members have voted. Clerk will please close the roll. House Bill 942 reports as amended by a vote of 15-7. Chair Simon.
And Delegate Hernandez, another wage garnishment bill. This one has some subcommittee amendments. I move the subcommittee amendments.
And a motion properly second to approve the subcommittee amendments. All in favor say aye. Aye. Opposed? All right, bill's amended. Chair
All
Simon.
right, and this bill has to do with wage garnishments and treasurer's liens for unpaid taxes and charges, and it limits a treasurer's lien issued with respect to wages or salary to 25% of the disposable earnings in a single pay period. The 25% limitation shall not apply if the lien issuer determines that an adjusted gross income of the delinquent taxpayer exceeds 250% of the poverty guideline amount adjusted for household size, or 2, that the treasurer determines by clear and convincing evidence that the delinquent taxpayer or the property assessed with such taxes is no longer in the jurisdiction, or the taxpayer is attempting to flee the jurisdiction, or is improperly disposing of assets with the intent to hinder or delay the collection of the delinquent taxes, provided, however, that the taxpayer may challenge such determination by filing a motion to reduce the lien in the circuit court of the jurisdiction in which the delinquent taxes are owed, and the lien shall be reduced to 25% from the time of filing until such time as the court has disposed of the motion, or 3, and finally, to any portion of the delinquent obligation collected by the delinquent taxpayer and held in trust to remit to the local governing authority. Subcommittee, did I move the amendments? There are amendments to this bill as well. I move the subcommittee amendments.
I thought we did. We already moved the
We already did it, sorry.
Are you ready? Make the motion.
This is the last one. All right, so the subcommittee moved reporting with amendments by a vote of 7-3, and I so move.
Got a motion properly second to report House Bill 1100 as amended. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. All members have voted. Clerk will please close the roll. House Bill 1100 reports as amended by a vote of 16-6. That complete your report, Chair Simon?
That completes my report, Mr.
All right, I'm
Chair.
going to turn to my Vice Chair Maldonado for a motion.
Thank you, Mr. Chair. Mr. Chair, having voted on the prevailing side in which we passed or carried over 5 bills to 2027, I ask that we reconsider that vote.
All right. Got a
Second.
motion properly second to reconsider the motion for those series of bills that we voted to carry over until 2027. All in favor, say aye. Aye. Opposed?
No.
Okay. So Chair Maldonado, you want to make a motion?
Thank you, Mr. Chair. Mr. Chair, I move that we include in the block to carry over to 2027 HB 364, HB 421, HB 604, and HB 863.
Okay. That's the motion. We go read that again.
HB 364, HB 421, HB 604, and HB 863.
And that's just 4 bills in the block.
Second.
All right, got a motion properly second to carry those bills mentioned by Chair Maldonado. All in favor say aye.
Aye.
Opposed? Okay. Those bills are carried over into 2027 under Rule 27, I think. 22. All right, that completes the business for the Courts Committee. The subcommittees will be working immediately upon adjournment of the full committee. With that, the committee shall rise.